families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to another episode of Families Divided TV. In this episode, attorney Brian Ludmer will be discussing a topic that is very intense all over the world. He's going to go into great detail. I hope you'll be taking notes. It's on false allegations in memory science. It's a very good topic, and it's a good presentation. I also want to wish you guys all a Merry Christmas and Happy Hanukkah. I know this is a difficult time for many of you and or of us. And I just want you to know you're in our thoughts and our prayers. Stay strong and trust God. We'll be back in just a minute with these messages, and then we'll have Brian Ludmer.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hello, everybody, and welcome to my presentation on memory science. I'd like to set the stage first so that everybody understands the importance of memory science in any case of fractured families where there are concerning allegations that are not true or exaggerated or taken out of context. We, of course, face these in every single case where someone is trying to justify a marginalized parenting plan or a non-existent parenting plan. So it is a pervasive problem. There are various recognized techniques, both in terms of structuring your legal case and responding just practically, and how to make your points in various forums with mediators, with parental coordinators, with custody evaluators, and ultimately, if need be, with the court. So those techniques, which I'll allude to, should be well understood in every case. And I'm going to be sending Elaine a series of documents, which she'll post probably on my page on Family Access, that I'll refer to throughout this presentation that you're all welcome to download. The first one was a presentation I put together for the Florida Bar Association that I gave last Christmas. And it is focused on how to prove your case, and inevitably in proving your case and trying to get a healthy family result, you're dealing with false allegations. There's a series of slides in that deck that you'll all have access to that is titled, How Do You Prove a Negative? And so I'll briefly refer to that, but the details of each of these techniques are set out in that presentation because I want to build on that understanding and focus on memory science, something where there's a lot more focus in the criminal law context and insufficient focus in the typical family law dispute. So how do you prove a negative, particularly when extreme child disengagement is being justified by the targeted parent or grandparent having been abusive. When I spoke at the PASG conference in Fort Collins, Colorado, I got a bit of a laugh when I mentioned that the word abuse is the most abused word in the English language. It's almost vacuous. It can mean anything to anybody. But the aspects of that are relevant to today's presentation are if you can disprove allegations of impaired parenting or grandparenting that supposedly rise to such a level that it can justify extreme child disengagement, then it serves two purposes. One, to show that there's no reason why you shouldn't be in the children's lives, and two, calling into question the credibility of just about anything and everything that the other side is saying. The implications for what the child is saying are also relevant. In court, though often forgotten, statements made by the children should be subject to the same standards of assessment of the credibility and reliability of those statements. And those are two different contexts. Credibility, of course, is a child making things up or grossly exaggerating things that they know not to be true in order to achieve the result that they want, which is to just go and live primarily or exclusively with one parent and have little to no involvement with the other parent and their extended family. Reliability, a different concept, goes to even absolutely believed statements of the child and even of the other side, but that you can unpack, peel back the layers of the onion and show that it is the result of grooming and manipulation and cognitive errors, misinterpretation of events and motives, and just built up over time into what is being expressed later on in the heat of the case, but which, if you went back down to its root, you would find something entirely different, entirely minor, entirely resolvable with a little bit of good faith discussion. And in this presentation, I also refer to the whack-a-mole model, which, for those of you familiar with the arcade game, every time you whack a mole, another mole or two pops up through other holes. And it's like that with these false narratives, where when you actually get a form and get the chance to shine a light on it, they just dissipate, only to be replaced by others that you've never even heard of before. So this is one of the techniques. If you can recognize the whack-a-mole sort of dynamic in a case, it's meaningful in terms of analyzing what's going on. So I had boiled down in this Florida Bar Association presentation about 15 or 16 tools of analysis in whatever I mentioned, about 5 or 6 forums that this could be relevant in. And I'll just mention them briefly here because I want to get to the brain science and you'll all have this presentation. So tool number 1, assemble objectively determinable facts and observations from people other than those directly involved in the case, and look at the children's behavior as opposed to what they're articulating at various points along the timeline of the alleged events. And you're trying to show as many discontinuities as possible. Tool 2, look for the illogical or atypical manner in which the allegations arose. Does it look like something scripted because even if it was true, it would arise at a time and in a manner and told to people in differently than what actually occurred? Tool 3, and here's where we're starting to introduce some memory science. Recovered memories of events supposedly having occurred long before are suspicious. Facts demonstrating non-compliance with the science of memory formation and the science of children being suggestible, there's a lot of science on that point as well, are important to bring forward. And that is because, as you'll see shortly, there's definitive science that the memory of events degrades over time, doesn't get enhanced over time. You don't suddenly recover vivid, detailed memories of an event. And it's also influenced by the environment in which the person is living, suggestion and coaching, and in particular, memory can be corrupted by repeated questioning over time, which suggests to the child that wasn't my experience, but why are all these adults continually asking me questions about, did my mom do this? Did my mom do that? Children and even adults tend to fill in gaps. So something doesn't fit, their experience is different than what all these adults are asking them to reflect about. And that can lead actually to a confabulation, or the creation of a memory by the mind to just connect disparate pieces of information in a way that then seems consistent with the child's experience. Confabulation can happen even with adults. And so I've gone through the first 3 tools. I just want to mention a classic example of a confabulation from a recent case of mine that led to this research on memory science. So it was a typical case of false allegations of sexual abuse. These are very, very difficult cases because of the distaste for the subject matter, and tends to trigger a very extreme protectionist element that, like, what if it's true? What if it's true? And the what if it's false? What if it's false aspect kind of gets secondary focus in the mind. There was a significant role of our local child protection authorities, and that role was highly damaging, highly negligent, and is currently the subject of a malicious prosecution suit. One of the issues was the fact that a new team of workers had come into the picture, done an incomplete and, as was subsequently held, flawed review of the extensive child protection file going back several years, and refused to speak with the previous caseworker who'd been working with the family for about a year, and I guess completely discounted his notes, his thoughts, his conclusions, and they rushed this cursory review to the police, which led to charges which were then completely withdrawn without condition, but still the whole process destroyed the family. We were exploring all of this during the trial. We knew that there had been no transfer meeting between the previous caseworker and the incoming caseworker and incoming supervisor. In the course of questioning, the well-meaning and obviously more competent previous caseworker, as he was trying to rationalize why there was no transfer meeting when it's standard practice, it's standard protocol, and he had had many other transfer meetings with the same people. And over the course of about a half hour of questioning, right in the middle of the trial, he went from being sure that there was no transfer meeting to suddenly vaguely remembering that there might have been, to then being convinced that there actually was a transfer meeting. And even when it was pointed out to him at that point that we had two other witnesses, who were the other people supposedly in the transfer meeting, who had denied and indeed were being vigorously cross-examined because of the negligence in not having a transfer meeting. It would have been in their interest to say, of course, there was a transfer meeting. And there was absolutely no record in writing, despite the highly regulated aspect of child protection authorities keeping written records, nowhere evidence of a transfer meeting. Even when that was pointed out to the competent and well-meaning child protection worker, he steadfastly held on to his memory of there being a transfer meeting on this family's file. We actually saw a vivid memory on his part being created over the course of a half hour of questioning, to the point where he withstood that final round of questions to him and said, no, I'm convinced there was a transfer meeting. This is an adult in a half hour of questioning where I was not trying to get him to accept that there was a transfer meeting. I accepted his original understanding that there was no transfer meeting. But in the course of the questioning, where I was really trying to go at the Child Protection Authority, his mind was forced to fill in the gaps and couldn't rationalize how it was possible for there not to be a transfer meeting, since these happen all the time. It's standard practice, and he's still working for that Child Protection Authority. And the only way his mind could fill in that gap is by creating the memory of the transfer meeting that I was not asking him to do. That is the power of confabulation of the human mind, even in an adult. Now, if you can imagine a child who doesn't have the power to push back on an invalidating parenting environment, who is being continually groomed and suggested and incentivized to develop adverse memories about a rejected parent, grandparent, aunt, uncle, whoever, it's easy to see how those false memories or exaggerations of something that has a kernel of truth could form. And when you not only think about memory formation and memory corruption and memory suggestibility theoretically, but when you've had the opportunity to watch a confabulation form in an adult in a half hour, when you weren't even asking that adult to form that memory or to admit that maybe they're mistaken, maybe they forgot, I wanted him to just stick with the truth. There was no transfer meeting, and yet his mind had to fill in the gap. So I developed over the course of this case even more of an appreciation of the importance of understanding memory science for the typical high conflict separation with all kinds of false allegations, particularly having seen it live and then researching the issue for closing submissions. But this is a topic I've been tracking over the years. So I'm going to go back to the list of just tools and techniques for how you deal with a false allegation, and then center us back on what do we know about memory science and how does one bring memory science into the discussion in any one of those forums, including the legal forum, where it could be relevant, and even experts, licensed mental health practitioners of various sorts don't have this knowledge. Okay, so I gone through 3. Tool 4, specialized psychiatric and psychological reports that might show that there's some pathology making someone much more hypervigilant, histrionic, and therefore at risk of developing false allegations. Were there requests that an allegation by a favored parent or child not be shared with the targeted parent? Well, that's an indicia of falsehood, because they should be hoping that they're not true and asking for input from the targeted parent or grandparent. When they say, well, just keep this between us because it wasn't verified, that's very telling. Tool 6, a child outwardly exhibiting no fear or reservations about being with a parent or grandparent, yet interviewing otherwise, or attempting to display false fear and anxiety in other forms. Tool 7, you piece together as many specifics of the allegations as possible in the exact wording used by the alleging parent or child to every other forum: investigators, therapists, schools, police, whatever forum, and you chart that out by date, forum, the specific language and content used, who was present in the interview, and what background was given to the interviewer. And then we use that extensively in the recent case. When you see the allegations morph over time. I had a case several years ago where a simple common experience of a child sleeping upstairs and the second child wanting to go upstairs and play and make noise, and a parent intercepts the child just before they go upstairs and says, no, the other child's sleeping, we can play down here. And in the course of just trying to prevent them from going upstairs, the child stumbles. That simple everyday occurrence morphed over time in the language of the alienating parent into, he tripped the child going down the stairs, he pushed the child down the stairs, he threw the child down the stairs. None of which is true, because the child was attempting to go upstairs. But when you see the allegation morph over time, it's a telltale sign of a falsity. Tool 8, you search for all discontinuities. Parents making false allegations will compartmentalize the information and not share the background. They'll attempt to silo the information with various third parties. And when you map that out, it just won't fit together. Tool 9, if the alleging parent or an aligned therapist or other aligned person is in the room or present at the child's interview, then whatever the child says might not be reliable. Alternatively, the parent may say, everything you say is going to be reported back to me, so remember to stay on point. Tool 10, was there any indication of prior discussions, probing, or coaching prior to the first professionally trained, non-suggestive interview? Because once a child's tainted, you can't undo the taint. So if a parent has, in effect, conducted the investigatory interview before the actual arm's length investigators conduct the child interview, and that isn't told to the child investigators, the whole process will be tainted. Tool 11, and I did this once to great effect in a trial, draw a diagram of the scene in which the alleged event took place. Then think of the different narratives about that incident in light of the physical layout of the room or the parking lot. And what will start to become apparent is the narrative couldn't possibly be true simply because of the layout and its kind of an open plan office or too many people walking by who could look in, and so highly unlikely that some sexual abuse of a child is going to be taking place in a busy open area, things of that sort. Tool 12, the timing of the alleged events, when they were first reported and to whom. Often we find a confluence between this will happen just before an assessment interview or just before a return to court. Very suspicious, particularly when the targeted parent is hypervigilant, has already been subject to false allegations, and is extremely likely to be parenting defensively and perfectly because they know they're under scrutiny. Tool 13, inconsistencies amongst the various allegations over time, accelerating, expanding, which invokes some of the other tools as well. Tool 14, failure to recognize that the base rate, so this is Bayesian reasoning, the base rate of the occurrence is so low that your starting clinical hypothesis should be that, as you would think it always should be, the person's innocent of this sort of thing until absolutely positively proven guilty. And unfortunately, with child sexual abuse, far too often, because of the extreme concern, the analysis starts off with guilty until proven innocent. Tool 15, repetition by a child of a story, even if consistent over time, does not add weight to the credibility or reliability of the allegation. So with those tools in mind, let's see how memory science plays in to how we deal with false and exaggerated allegations. Memory science as a science developed extensively over the last 50 years. In fact, memory science as a science got accelerated by the work of Elizabeth Loftus and others involved with the False Memory Syndrome Foundation as a result of the pervasive and difficult nature of these matters in criminal law, but then ultimately in the false memory scandals of the 70s and 80s, memorialized even in some movies, particularly dealing with the McMartin Day School on the West Coast. You could even think of the Salem witch trials, where one crazy story morphed into another and it became almost like a mania, was an example as well. So through Elizabeth Loftus' work, that interests many other practitioners to enter the field, and we have a tremendous amount of science today on how memory works and how popular misconceptions of how memory works are plaguing helping fractured families. But it's not well known, and far from what we need it to be known if we're going to do justice in these cases. A good mass market publication to understand some of the more technical aspects is a book called The Memory Illusion, Remembering, Forgetting, and the Science of False Memory by Dr. Julia Shaw, originally published in June 2016 and still readily available in print. The summary of the takeaways from memory science that you would get from reading that book and a whole bunch of textbooks and other publications that will be available on the Family Access website when I send Elaine the updated list, can be found in a publication of the Research Board of the British Psychological Society from June 2008, which I recently had occasion to discuss with a professor of memory science who spoke on memory science at the recent Parental Alienation Study Group conference in Colorado. And in our dialogue, he indicated that these takeaways from this publication, which after all, guidelines on memory and the law. So this is an official statement of what, in effect, judges should take judicial notice of, because it is so well settled in the science, we shouldn't have to redebate these 10 principles in every single case. We need to make it easy and accessible for parents and grandparents to litigate these cases. Here are the 10 points that are settled science. Number 1, memories are records of people's experiences of events and are not a record of the event itself. So our mind forms impressions and feelings of an event, but does not capture the event itself. Number 2, memory is not only of experienced events, but it is also of the knowledge of a person's life, i.e. schools, occupations, holidays, friends, homes, achievements, failures, etc. Number 3, remembering is a constructive process. This is probably the most important point. Probably better said as memory is a reconstructive process. So most people think of memory like a digital media file, and you can play a song on iTunes 1,000 times and it will reproduce perfectly, bit by bit by bit. Memory is the exact opposite. Every single time you attempt to recall a memory from long-term memory to short-term memory, your mind recreates it based on the totality of all information available, all experiences, all facts, everything you've read, seen, heard, feelings, go into the reconstruction of the memory at the time of recall. And you recall that memory into an existing environment, and it gets further affected and then re-encoded into long-term memory in changed form yet again. And the minute you understand that aspect of memory science, you start to really understand that a child exposed to influences and suggestibility and grooming over the years using all the techniques that people do when they are trying to form false memories, their memory may be distinctly unreliable, even if credible in the sense that the child truly believes it. Memory science would suggest that it's unreliable. Point 4, memories for experienced events are always incomplete. Point 5, memories typically contain only a few highly specific details. Point 6, recall of a single or several highly specific details does not guarantee that a memory is accurate or even that it occurred. Think of the confabulation of the child protection worker that I just described. Point 7, the content of memories arises from an individual's comprehension of an experience, both conscious and unconscious. But that's not how what a child's saying gets used in court, that it could even be an unconscious contribution to a memory. Point 8, people can remember events that they have not in reality experienced. Point 9, memories for traumatic experiences, childhood events, interview and identification practices, and memory in younger children and older adults and older vulnerable groups all have special features to them. You have to understand the subtleties and nuances of memory science for each group. And point 10, a memory expert is a person who is recognized by the memory research community to be a memory researcher. And my final comments will relate to that last piece. So do you or don't you need a memory science expert in every legal case where there are material false allegations? Is this part of a judge's general understanding in parsing the credibility and reliability, which I've indicated are two different things, of all witnesses' testimony, so that the judge doesn't need the help of a memory science expert? And that's one of the tests for the admission legally of expert evidence. Or are there aspects of a particular case where the court would be assisted by a memory science expert in reviewing the evidence and parsing that evidence against memory science, or just assisting the court with an explanation of memory science in the sense that I've just given you? Unfortunately, the law is unclear. In researching this issue for my submissions in the recent case, I found a lot of cases where judges did not accept the memory science expert to give an expert report on the basis that they already knew all that. As to whether they really did or whether they were actually prepared to apply that all, different story. But other cases where the very same memory expert or others were accepted to put in an expert report on the basis that the court felt that this was not within the common understanding of a judge, and that there were aspects of the particular case where the court would be greatly assisted by having this expert knowledge. So it does make it difficult for the legal practitioner. There's certain advantages if the budget is there to try, but also if you're in a situation where you can't afford a memory science expert, you do have the case law where you could put in, for example, the British Psychological Society publication and state, well, Your Honor, here's a whole bunch of cases that say you're supposed to know all of this. So this publication is just to help you know what you need to take judicial notice of. And so that concludes my remarks here today on memory science and how it is relevant for work with fractured families and false allegations. Thank you for listening.
Next week on Families Divided TV, Sally Harris will be instructing us on how to stop letting estrangement control your life. Reclaim control and find peace.